at 1:30?
Yeah, they do them at 1:30, and normally we, like on a day like today, Your Honor, we would have been done, but we had a couple special customers.
Well, I would have probably sent it later, but all right, thank you for joining us. This is an old file. It's 163281. People versus Tyler Loy. Tyler Lee Loy. Is that you, sir?
Yes, it is, Your Honor.
All right. In 2016, you were charged with domestic assault on your partner, Amanda Quinn. You gave her a fat lip, and we spent a lot of time on this matter. I did a judgment of sentence on January 23rd of 2017. I sentenced you to 12 months probation with the possibility that you could get off probation after 6 months. I lifted the no contact provision so that you could have contact with Ms. Quinn. And I did a fine of $285 after I applied your bond. I also gave you 14 days jail credit for leaving 10 days to serve, and I deferred those 10 days. I also ordered that you not engage in any assault or threatening behavior, and you do our anger management class. I put you on the probation, and then you promptly disappeared. So we set in fact, I don't know that you ever did anything. We set a probation violation hearing for June of 2017. You didn't show up for that, and I issued a bench warrant for your arrest, and I've been maintaining that bench warrant for 9 years ever since. Done a couple internet searches to look for you. I think we even sent an order to show cause at one time. Anyway, recently you got arrested. How did you come to get arrested?
I was just at a stoplight, just driving the motorcycle, and I was just sitting at the stop sign, and then a cop just started running at me, so I just put my hands up.
And where was this?
Like right off of M60.
M60 where?
Like Cass, towards Cass.
So did you get arrested in Cass County?
Honestly, I don't even know where I was. I'm a caretaker for the victim that we're talking about. She's paralyzed, so I'm a 24-hour caregiver for her. And I was just taking an hour break like I do on a day. So either I'll go out and I'll go to the store or go do stuff, or I'll go ride the bike real quick for an hour, and then I have to go back because she's paralyzed. She can't get out of bed. And that's all I was doing. I was just going for a ride, and I was gone for 30 minutes, and then he pulled me over. And then that's why I did, and he said nothing.
Did you get a ticket for anything?
No, I didn't get pulled over for doing any violations. He said that he just seen me driving by and he read my tags, and then my tags came up. And I told him I didn't even know nothing about this, because what happened was when you assigned me to probation, I came to the first 3 meetings and I paid the lady at the window, but every time I showed up, there was no probation officer there. So the lady would have me sit in the chair by her window, and I sat there for like 15 minutes, and I did that 3 different times. And so where I would go there and I would pay, and then they kept telling me that the probation officer had issues or something. They didn't tell me exactly, but he never showed up. So then on the 3rd one, I informed her at the window. I was like, I don't live in Michigan. I don't know anything about Michigan. I live in Indiana. When this happened, I still lived in Indiana. So I wrote her down my address, and I gave her everything I could, and I showed her my ID, and she said, if we have any more questions, we're going to send you mail to this address. Well, I waited and like a month or 2, and then I ended up calling to the courthouse, and they said there's no warrants or nothing on me. So I was like, okay. I just didn't know what, so I waited and waited and waited, and then about 3 years after that, I went and I bought a house. So that's where my new address has been the whole time, is the house that me and Amanda had purchased.
What's your new address?
My new address is 5.
Just tell me the town.
Oh, sorry. It's Elkhart, Indiana.
All right. I looked up 58177, apartment 3, Elkhart, Indiana. Were you at Lowell Street at one time?
Lowell Street. Oh, yeah. That was when I was 18. I was 18 and 19 when we bought that. That was before I think this happened. The address, I'm pretty
Your
sure.
probation agent had cancer. And she was very ill for a period of time, and she finally succumbed to it. So she wasn't always here. But you just went off the radar. You didn't finish paying your fines and costs. You never did the anger management class. And they gave me the probation file, so let me see what that shows.
Because that's when I asked the lady, she said that she was gonna send me letters, and either she gave me three options. She's like, most likely what'll happen is we'll send it to Elkhart and we'll try to get you moved there since you live there and you keep coming here. And then she said, or since we've had so many problems, we'll have you finish paying off, and then we'll move on from there. And she said there was three options. I was just waiting for the letter, and after so many months went by, I called. And the lady at the courthouse, she didn't say anything about me having to continue. So that's why I left my, the address with the 30106 Wolf.
Yes.
And I said, if you have any problems, then let me know there. But then I think.
Which they did. They sent you a letter. They had a hard time getting your intake done, and they finally got it in February and went over everything. Then you didn't show up in February, and they sent a delinquency notice to Wolf Road. You didn't show up in March, they sent a delinquency notice. You didn't show up in April, they sent a delinquency notice. Then we set a hearing called an order to show cause for June. I don't know where they sent that to. Let's see if I can tell.
It should be Wolf Avenue, not Wolf Road, because we've never gotten any mail. I promise you, I'd have took care of it. I've done so much stuff. I've gotten everything straight. I've been working everything. But yeah, the person we're talking about, Amanda, she's actually at home right now. She's with my children. She can't move. She has Guillain-Barré syndrome. I've been getting paid through the government to take care of her. After we did the jail thing and I figured everything out, like I thought I figured it out. I guess I didn't. We had ended up getting her in 2017 and signed up in Oakland. They figured out she had schizophrenia, all that other stuff. So we've been taking care of all that for all those years. And then around 2021 or 22 is when she got Guillain-Barré syndrome, and she became paralyzed and she can't get out of bed anymore. So I've been taking care of her ever since then.
Well, essentially, we haven't heard from you, according to the notes in the file, since February of 2017.
Yeah, I'm sorry. I thought we were all done after I talked to that lady. I didn't know.
We never even got started. They did you did your intake. Also gave them information to get signed up for the anger management classes at the Day Reporting Center. He may wish to do the classes in Elkhart since he lives down there and they would be closer. He works at Lippert and gets out of work by 2:30, has to pick up his kids at 3:30, may have a hard time getting here by 4 o'clock. He would need to talk to Daniel, his probation officer, about this. That was in February of 2017. Then we never saw you again.
Yes, sir. Like I said, I thought I was done. I didn't know. I'm very sorry.
Well, you're
That's why I
trying
gave him all my
to resurrect
information.
something that happened 10 years ago. You basically, you just went back to Indiana and we never saw you again. I ordered a 10-day jail sentence that was deferred. I could order up to 93 days. So let's talk about what happened. They set a probation violation arraignment, which you never showed up for. We sent it to Wolf Avenue, Elkhart, Indiana. Home phone. They tried calling you, they sent you some mail, we never heard from you again. So
Yeah,
I've had this
2017.
warrant out for 9 years.
All right, buckle up because this case is straight out of a legal thriller. Back in 2016, Tyler Loy was charged with domestic assault against his partner, Amanda Quinn. The judge gave him probation, ordered anger management, and even cut him a break, lifting the no-contact order so he could stay connected to Amanda. Sounds like a second chance, right? But instead of following through, Tyler vanished. And for 9 years, yes, nearly a decade, a bench warrant for his arrest has been sitting open, gathering dust. Now, after all this time, he's suddenly back in front of the same judge, the same probation officer, even the same defense attorney. The only thing missing is the life he was supposed to rebuild responsibly. The question is, does he get another chance, or is this where patience runs out? Stick around, you'll want to hear how this unfolds.
Yeah, I'm
Or
so
you
sorry.
doing nothing that you were supposed to do on this probation. But now, 10 years have passed since the incident. She needs your daily care, and me putting you in jail for 90 days would certainly be a definite hardship for your family.
Yeah, and I didn't want to mess up when I got here, and I didn't want to call her because they said I couldn't call the victim. But I was freaking out because that's who I take care of every day. And the lady
Well,
was gonna let me call her.
I lifted the no contact provision way back
Okay.
when.
Okay.
I allowed you to have contact with her. I let you out of jail. I deferred 10 days of jail, offered to take this off your record if you completed the probation, offered to
Yes.
cut the probation period in half, from a year to 6 months, and you paid me back by giving me the finger and never showing up again. You showed up
I'm
for
so
your
sorry.
intake.
Did
and
they
never
have
once
proof that I
again.
showed up? Did they have proof that I showed up those 3 times?
No, there's no indication you were, but yeah, before then, you showed up between,
For the first and second and
sentencing
third.
date. Yes,
Because I know I showed up 3 different times in 3 different months to pay and go to my
No.
meeting, but every time
No.
she wasn't there. I was just so confused. I've never been in trouble like this before. I never done anything. So when I thought like that they were doing all that in the court, and then her not showing up, and then you said everything was, I didn't know. That's why I asked. I asked her if we could get it switched, and she said possibly since you've been coming, we'll just cut it, and then you'll have to pay the fee, or we'll switch it, and then you'll have to keep going. And I waited, and I'm sorry. I'm truly sorry. I waited and waited, and then we ended up buying a house after years later because like everything we thought was done. I really didn't mean to just dip out on you guys like that. I thought I was truly done.
well, 90 days from now, minus 4, would be 30, 60, sometime in early December, no, mid-December, before Christmas. Anyway, let's go back to square one. The allegation is that you violated your probation by failing to report. Probation violation hearing was set for June,
I'm sorry.
which you never showed up at. And we haven't found you in 9 years, and you got accidentally arrested. Failed to report, failed to contact, failed to have any intake appointments since February 1st of 2017. So anything you did before that was before we actually did the intake. So
Okay.
you never finished paying your fines, you never did the anger management class, and you been AWOL for 9 years. All right, I'm going to show you plead not guilty.
Because when we initially got it done, she came in and I thought she
Stop,
explained that.
stop.
Sorry.
You totally dropped the ball on this, and anything that you say now is just a pale excuse for the fact that you blew off your probation 10 years ago. I'm trying to give some consideration because your girlfriend, did you ever get married?
Yeah, I mean, no, we didn't get married because she ended up getting paralyzed, and we're literally just getting our lives built back to where everything's normal. Like we're not struggling with bills anymore. We're not, you know what I mean? Everything's not like horrible. We're actually on top. I got my license. I've got my motorcycle license now. I've got my CPR license. Like I've done so much stuff. I 100% truly didn't mean to do this to you guys. And like, I called the chick to make.
Stop whining about it. You did mean to do it. You just blew it off. Now, you've changed your life in the last 10 years, but you got frustrated because you had to wait 15 minutes before your probation officer could see you because she was dealing with cancer. And then you never showed up again after February 1st of 2017, despite numerous letters that we sent to your house. We scheduled it for a hearing and they sent it to 30106 Wolf Avenue, Elkhart, Indiana, 46516, which is the address that you gave us. You didn't show up for the probation violation hearing, so a bench warrant issued for your arrest. I'm going to show that you're going to plead not guilty to the probation violation. I'm going to appoint an attorney. The original attorney was John Bush, who is still practicing. I'm still here. Daniel Frazine is still here. Gina Wagner is not. Now, my fear is if I let you out of jail, you're going to bug out on me again, and I have to hold this open for another 10 years. You need to take care of this.
I'll give you my address I live now. I'll give you my phone numbers.
What? All right, well, we're going to need all that.
I'll give you my job numbers.
All right, well, where do you work?
I work at Black Pearl Life Care.
What is that?
The caretaking service for the elderly or disabled.
All right, my original thought is just going to leave you in jail until such time as we could schedule a hearing. Because
I promise you I'll come back. I just didn't know.
You did know, so stop saying that. You're going to talk me into giving you 90 days in jail. What I got in mind is trying to work out weekends or something so there could be care for your girlfriend, who you went with for 10 years but never got married.
Yeah, because I haven't been away from her since she got sick. Not one day, not 24 hours, not 5 hours.
Okay.
I'm sorry. I've been worried all night.
All right. I don't know what that date for the PV is yet. I'm going to set, originally, like I said, I was going to let you set. I'm going to set a PR bond. Need address and phone information.
Okay.
I told you I was going to give you 10 days jail if you didn't do what I asked you to do, and you did none of it. And potentially, you could get the balance of 93 days, which is 89 days. So the allegation is that you failed to report to your probation officer after February 1st of 2017. You failed to appear for your probation violation arraignment, or ever after that try to contact anybody after February of 2017. And I had this warrant. I made a couple efforts over the years. 2017, and some notes. 2024, I found an old address.
Because in 2017 is when I bought my house at the 57588 Best Avenue.
Give me that again.
It's 57588 BEST Avenue, 46516, Elkhart, Indiana. I'm sorry, 46517.
57588.
BEST Best Avenue.
57588.
Yes.
All right. You got to get out of jail, and you're going to appear for your next court hearing, or I'll set bond at like $9 million and send somebody down to get you. You're going to bring closure to this.
I'll be there.
You're more mature. And it wasn't a not inconsequential assault. There were pictures of it. She had a big fat lip. We spent a lot of time talking to her. She gave a lot of victim input. She was in your corner. I lifted the no contact provision. But basically, I sentenced you on January the 5th. No, January 23rd. You came a couple times between January 23rd and February 1st, and then we never saw you again. All right, so they're going to give you a $500 PR bond.
Okay.
I originally thought I was just going to leave you in jail and have this hearing on Tuesday, but I don't want her to be in a precarious position.
I thank you for that.
But there's going to be a consequence to this, which may be 5 weekends in jail or 89 days. We'll see where we're headed. But this is not going to be very hard to prove. The allegation is you failed to appear, and you failed to appear for 9 years.
Yeah.
All right. I don't know what date I'm going to see you, but we will see you, and we'll get notice to Mr. Bush, and we'll get notice to you that you need to appear for.
Okay, thank you.
All right. You're good to go. I'll be seeing you.
Thank you, Honor.
Thank you, Keith. Same judge, same probation officer, same defense attorney, same complainant. Everybody's here except Gina, who might have been able to fill in some of the gaps, but the bottom line is he just never showed up again. So we'll get John Bush on board, set a probation violation hearing, and see where we go from there. Thank you. All right. Now,
And there you have it. Tyler Loy spent nearly a decade running from probation requirements that were designed to help him turn his life around. The judge reminded him that this wasn't just a paperwork issue. He skipped anger management, unpaid fines, and most importantly, ignored a court order. Now, while the judge is balancing compassion for Amanda's medical needs with the law's demand for accountability, Tyler still faces the real possibility of serving weekends, or even months, in jail. This is a textbook example of how ignoring probation doesn't make it disappear. It only makes the consequences bigger when they finally catch up. What do you think? Should the judge show mercy after 9 years, or is it time Tyler finally pays the price?
I need Tim George, Jordan Harden, and they were both had circuit court obligations, I think also. So they're trying to cover everything. I'm going to break wherever I am for a competency hearing with Rhonda Ives, because Rhonda Ives is so difficult to schedule. Good afternoon, sir.
Make a difference.
All right, we're on the record, we're on the live stream, and we are ready to start. The first matter we're going to address is Philip Leroy Burlew. That's you, sir?
Yes.
You got multiple cases. File 257617 is a no insurance from April 2nd. File 22800ST is a driving suspended second, no insurance, and unlawful plate from April of 2022. Then Mr. Burlew went off the grid for a while. Then he has a no ops, April 2nd, which is co-occurring with the no insurance. That's file 25618ST. And then he has an unlawful registration plate, which is also April 2nd. So essentially, some of this is from 2022, and then the rest of it is from April of 2025. Mr. George, what's the status here?
Thank you, Your Honor. The prosecutor has tendered an offer that if he were to enter a plea to operating without insurance and no valid operator's license in the most recent case, then everything else would be dismissed.
You agree with that, Ms. Canfield?
I do, Your Honor, I concur.
All right, Mr. Burlow. No insurance is a charge that carries up to a year in jail, a fine of not less than $200 and not more than $500. And then the no operator's license from 2025. And then unlawful use of registration plate would be dismissed. And the 2022 case of driving without insurance, driving suspended would be dismissed. All right.
It works.
Did you give me a cheat sheet for this afternoon and did I lose it or did I not have? Okay. All right. That's all right. Thank you. All right. So we're going to dismiss the 2022 stuff outright. Dismiss the improper plate. You're going to enter a plea to driving without insurance and no valid operator's license. The no ops charge is a misdemeanor. It's punishable by up to 90 days in jail and a fine of up to $100. It also carries 2 points on your driving record. You understand?
Yes.
Other than that plea offer, did anybody promise you anything
No.
or threaten you?
No.
You understand you're giving up all those rights that you signed on this advice of rights by entering this plea. You're driving a car here in St. Joe County in April of this year,
Yes.
April 2nd. Did you not have insurance at that time?
No, I didn't have any.
And did you have a valid operator's license?
No.
Where were you going?
I was going to the Walmart to pick up my prescription because I had gout and I was in pain.
Well, I think that's what you told me at your arraignment. Back in 22, they charged with driving suspended. This time they cut you a break and did no ops. What's the status of your license as far as you know?
I have a lifetime suspension. I gotta go. I went down to Indiana and got the paperwork to get my specialized driving privileges. I just gotta get that turned back in and then I get to go to court.
In Indiana?
Yes. I have to get my Indiana cleared before I can get one up here.
Well, then you should stop driving.
Yeah.
You got charged in 2002 and then you bugged out for 3 years till you got charged with the new stuff. I just talked with a guy that's been AWOL for 10 years, but I have a long memory that's fading fast. What do you do now? Do you work someplace?
Yeah, I work at Eagle Auto.
Okay.
I've been there for 3 years.
Let's take a look at this. Did you go to jail when you got picked up on the new charges?
Yes. No. Yes.
Yeah, we had a warrant. You got arrested on April 3rd and you posted bond. So you got actually on the 2nd. So posted bond. Yeah, you got arrested April 2nd and you posted a bond. So I should have some money in there. Let me look at this. I held up that old file that had a bond resale. I got $500 worth of bond posted April 3rd. All right. This is going to be something we can resolve. All right, I'll give you 1 day credit, 1 day on the no insurance. Leaving 0 days to serve. There's a minimum $200 fine. That's set by statute. There's a $75 crime victims' rights fee and a $50 state minimum fee and a $150 attorney fee. $475. I don't know if that bond is a 10% bond. $500. So apply $500 of bond from 22800 ST. So that takes care of the no insurance. The no ops. That's 25618. I'm gonna order a $100 fine. There's $25 worth of bond left, so you owe $75. Can you pay that today?
Yes.
All right, this is gonna go on your driving record, put 2 points on it. How'd you get here?
My mother-in-law, she's still out there waiting for me.
All right. Well, stop driving till you get this straightened out. Give you 1 day credit, 1 day on that one also.
Thank you.
Well, the prosecutor dismissed the DWLS, which would have further suspended it. But it's always funny when people have to pay the fine, they don't have any money. But when it comes to bonding out of jail, they do pretty good. All right, I'm gonna have the clerk, the bailiff take you out to the clerks. Hopefully they can decipher this. And hopefully I got that bond right. Let me look in that other file, see if there's a bond in there. No. All right, good luck, sir. We've got about 12 minutes to try to do our next one before we have to log into the forensics center.
I think Jordan has a quick one.
All right, Jordan, what have you got for me?
Mr. Alcantara, so you can go on another, so just city case.
Yes, that's good to know. Thank you, that's very helpful. Good afternoon, sir. Are you Salvador Alcantara?
Yes, I am, Your Honor.
In the instant case, which is file 251060, and a civil infraction of disobeying a traffic control device, that's going to be dismissed. That's going to save you $125. On the no operator's license charge, they're going to dismiss that for a plea to allowing another to violate the motor vehicle code. Is that correct, Ms. Canfield?
It is.
That offense carries no points, doesn't get abstracted to your driver's license, won't affect your ability to keep or maintain your license. Do you understand?
Yes.
Other than that plea agreement, did anyone promise you anything to get you to plead to this
No, Your Honor.
or threaten you?
No, Your Honor.
Were you driving a car?
And it starts with a bang. Meet Philip Leroy Burlow. Multiple cases, multiple years, and a driving record that looks more like a rap sheet. We're talking no insurance, suspended licenses, improper plates, and a history of disappearing off the grid. The prosecutor has an offer on the table: plead guilty to just 2 charges, and the rest vanish like smoke. But here's the kicker: even reduced charges carry fines, jail time, and lasting damage to his record. Now, Burlow claims he was just driving to Walmart for pain meds, but the judge isn't buying excuses, especially from a man with a lifetime suspension. The stakes? Pay now and take the hit, or risk digging himself an even deeper hole. Stick around, because this hearing isn't just about traffic violations, it's about accountability, leniency, and whether the justice system believes in second chances. Or third, or fourth.
Here in St. Joe County on June 5th,
Yes, I was, Your Honor.
and did you not have a valid license at that time?
Yes. No, I did not, Your Honor.
Did you run a red light or something?
So it was, I didn't know that road at all. So it was right next to like the Great Lakes coffee shop.
I don't
Oh,
need
but
to
it
know
was
that.
a one way.
All right. Oh, that's what it was.
Yeah,
But you didn't have a valid license.
I did not.
All right. Okay.
He did bring a copy of his permit today, Your Honor, to court, so he is on the right track, which is why the offer was provided.
Very good. Yeah, he's got some baggage. He owes me $953 in unpaid tickets. 2023, failed to display a valid license, which he never paid the fine. 2024, no proof of insurance, $258, he never paid the fine. And he got a previous break for allowing another to violate the motor vehicle code in 2021. He never paid that fine. So you got $953 worth of unpaid fines on previous tickets. So I'm not sure why I'd want to just give you a fine in this case in light of the fact that you don't pay your fines in your last case. So what I'm going to do is I'm going to set this out for sentencing and see whether you pay your existing fines. Otherwise, I'll just put you in jail and then we can wipe out all the fines. But you got to break twice. You got allowing another to violate the motor vehicle code in 2021, never paid the fine. That offends my sensibilities. Then you got to fail to display a valid license in 2023, which started as a driving suspended or no ops, and they reduced it. You didn't pay that either. Then you got a no proof of insurance, which was reduced from no insurance. You didn't pay that either. So you're going to pay those, or I can just make a package and you can do some jail time and wipe out all the fines. All right. You'd rather pay the fines?
Yes,
I would rather you did.
yes.
Jordan, you've got some dates coming up.
My next date with you that's decently set out is the 13th of October.
All right.
Month. But I'm over here on the 20th for statuses upstairs, so
That'll work. What time are you set for that day?
they're at 9:15. I have about 8 of them.
No, what time are you set for October 13th?
Oh,
10:30.
10:30. Yeah,
All right, I'll set this for 10:30.
thank you.
That's the one with a bond in it.
Yeah, that wasn't planned.
I want you to take Mr. Alcantar and give him a formal notice for October 13th at 10:30. Here's what you owe. I want you to pay those. I'm trusting you will, because I think you'd rather do that than go to jail. But it hurts my feelings when they cut you a break and you get a fine and then you don't pay 1 penny on it. Then they give you another break, which is maybe more than you deserve, but you got it. So I want you to pay your old fines. Jenny? I'll take this file also. You go out to the counter and see the ladies and talk about those fines, and they're gonna give you a notice for your next hearing date. And this goes with that too, I'm sorry. Tim, is Mr. Bryant here?
Yes.
All right. That's a little complicated. What do you know about your cases, Tim? What are we gonna do? All right, let's talk to Miss Niffen. See if we can do this in 6 minutes.
This is a no contest plea, Your Honor.
All right. Plea no contest to what?
Operating while intoxicated.
And then we would dismiss the 2023 case of improper plates and no ops. That's 23843. All right. What's left, Miss Niffen, is a charge of operating while intoxicated with a high blood alcohol level. This is a little complicated. We've been sort of in and out of the picture over the last couple of years. But this occurred at 8:30 at night, Driftwood Drive and Farron Road over by Colon. That's a long way from where you live. It's kind of not exactly in the middle of nowhere, but it is certainly out in the country. They gave you a breath test. The PBT was 0.96.
If I may assist the court,
Yes,
there is a laboratory report record number 1 shows a 0.09 blood alcohol level, and laboratory report record number 3 shows a substance analysis with amphetamine and methamphetamine results of the initial 13 nanograms per ml for amphetamine, 114 nanograms per ml for methamphetamine.
all right, so it's a combination of alcohol and other controlled substances.
Correct, Your Honor.
Now, Ms. Niffen, by pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Do you understand?
Yes, sir.
And sometimes it's due to lack of recollection or other factors. Do you not have a clear memory of this?
I was so drunk. I just remember not being able to get off the ground, and Charles was in the driver's seat, and I don't know if he was trying to run me over, go around me, or what. But
Who is Charles?
Charles Allen is the one that I was dating. That's who I was living with a colon, and he was. It even stated on that.
That's how you happen to be over in that neck of the woods. All right. Now, Mr. George gave me an advice of rights. You understand, by pleading to this, he'll give up all the rights that go with that, including the right to have a trial.
Yes, sir.
I don't know. We lost track of you. So you got arrested, then you got arrested again. In 24, then you got arrested again. You had to calculate how much time credit you have. Then we caught up with you in June. I set all your cases for a pretrial with Mr. George for July 12th. That was Judge Pattison. He gave it back to me. He missed another court date, issued another bench warrant. All right, the ticket indicates the defendant was driving at Farron Road. And Driftwood Drive, near Colon. I think that's where the prosecutor lives. Oops, that's Mr. Alcantar. And that her blood alcohol was 0.098, supplemented by the prosecutor. The laboratory report also showed the presence of methamphetamine, which is a legitimate reason for no contest and supports a factual basis. Defendant admitted drinking before driving. And it had an improper plate on it. The good news is you're here now. What town do you live in?
I actually live in Galesburg, even though I was staying at Youngman Road.
All right, we're gonna need to get well, I got the Youngman Road address on here, lot 35.
That's just like my mailing address. I don't live there no more. I'm staying with my mom. She takes me to rehab and all that. It's just a better environment.
All right. Well, I'm glad to hear that. I'm a little worried because the forensic center hasn't logged in yet.
In Your Honor, we did have another case recently where court is set for sentencing on October 21st in front of Judge
I
Pattison.
saw that.
That also has a PSI along with it. So
Yes.
I know she's actively seeking treatment, maybe even wants to seek inpatient treatment. So
I'll see what October 21st is. It's a Tuesday. Maybe we'll set it at the same time.
I think I have her at 10:30, Your Honor.
Well, I'll set her for 11. 10. It says here 9/12. What date's it set for?
10:21.
All right. That's a pre-exam day for me, but whatever I'm doing, I'll be able to make time at 11. All right, Ms. Niffen, I want you to take this form out to the counter. I want you also give them your mom's. Let me give you the rest of this. And, thank you, Michelle.
You're welcome, sir.
Laura, the Forensic Center is not joining us on Mr. Juday, which leads me to believe maybe we've got a bit of a glitch. All right, well, we'll take another case then, as long as it's in the works. Tim, what else have you got for me?
I've got Mr. Crystal, Mr. Carmen, and Mr. Brian.
All right,
Mr. Conley.
all right. Good morning, sir. Good afternoon. You're Alexander Bryant Conley.
Yes, sir. Good afternoon.
Mr. Conley, you got charged with operating with a high blood alcohol and possession of a firearm under the influence. Let's take a look at yours. Let's get Ms. Niffen out of here. It wasn't a ticket. Let me see if I can find a complaint. The complaint alleges that one point it says you live in Union City, and another point says you live in Lawrence.
Yeah, it's Union City, sir. Lawrence was that wrong?
Yeah, Arbogast Road is in Union City. There's a lot of famous people like Keely Beamer that come from Union City.
It's a nice little town, for sure.
Yes. All right. It's alleged that on June 26, you were driving a vehicle on Custer Road here in Colon Township with a blood alcohol over 0.07, and that you also possessed a firearm at that time. First charge is a misdemeanor punishable by up to 6 months in jail and a fine of up to $750. It causes the suspension of your driving privileges and puts 6 points on your driving record. Ms. Canfield, what's the plea offer here?
It's my understanding that Mr. Conley will be entering a plea of guilty to the lesser included offense of operating while intoxicated, at which time we would dismiss the operating with a BAC of 0.17 or higher. He's also entering a plea of, let me change that to no contest to possession of a firearm under the influence. So those will be no contest, and I'm fine with a factual basis. I can help you with that if the court needs assistance. I don't know what's in the bond report.
All right, well, let's take a look. All right, possession of firearm under the influence, let me go back to the complaint, is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $100 or $500 if you discharge it. It also requires that the weapon be forfeited. It's kind of a bit grounded up. As I told the other lady, by pleading no contest, you don't admit what happened, but you also don't deny what happened, and you would allow or accept that a conviction would enter. Sometimes, as in the last case, no contest rationale would be that the blood alcohol was high enough that you don't really remember. His PBT at the jail was 0.189. What's the BAC we're using for the plea?
The blood was 0.228, Your Honor.
What were you driving? That Mercedes that you got outside?
I don't have a Mercedes, sir. I wish. Chevy Colorado.
All right.
But I actually wasn't driving.
I thought I saw you outside in a Mercedes.
Oh, no, I did drive today. I thought you were talking about that night.
Yeah. Were you in a Mercedes today?
No, Chevy Colorado.
Oh, then it wasn't you that I saw. I thought, that's a nice car. All right. Let's see what I have for a factual basis. At about 1:30, I responded to Custer Road in Coleman Township regarding a burglary in process. Alexander Bryant was located by Centerville Constantine police officers a long way from home and detained. PBT 265, oh my. And a handgun and a holster with a magazine and a full pistol magazine. 6 hour underneath the back seat. Not registered. This hit's kind of close to home. Homeowners Todd and Katie Stoll, who told me it's the first time Conley's been on their property, they don't know who he is. He walked to the north side of the residence, where he walked on a plexiglass window to the house and fell inside. Oh my.
Knocking on their bedroom window.
Okay.
I went there to drink with them, sir.
With the Stolls?
Yeah.
Well, they said they didn't even know who you were.
Yeah, apparently they don't like me because they definitely do.
Well, they probably didn't like you much after this. Okay.
Yeah, I was knocking on the bedroom window and then I fell into a basement egress. And I'm assuming that's why the burglary
I think
was placed, but as you can see, I wasn't charged with that.
no, it's not a burglary. But it is a real drunk guy driving a car around with a loaded
Well,
gun.
I went there to drink with him. I started drinking when I got there. And then I knocked on the window, went back to the truck, continued drinking, waiting for them to come out. They didn't. That's when I decided, I can't drive. And I was bleeding because I cut my arm when I fell through the egress window. So
For a guy
sat in
that's
the
pleading no
grass.
contest due to lack of memory, you sure have a pretty good memory of what happened. So I can't really ask you any facts about it if it's a no contest plea. Also, when the blood alcohol is more than 3 times the legal limit, that's very drunk.
Your Honor,
Yes?
based on my client's comments, I don't think it's appropriate to enter a plea. I think it would probably just be best course of action to just set this for a trial.
All right. I was shown video footage of Conley driving his truck into the driveway where he drove over a retaining wall, remained on for a few minutes. Then he stepped out the driver's side door. He was not seen drinking anything while on scene. All right, you can have a trial if you want. Well, we'll set this for trial for December 10th. You probably don't have the witnesses. I'll ask for witness and exhibit list within 21 days. Now we've got lab reports, videos. Would you stipulate to the blood draw or the lab expert?
I can talk to Mr. Conley about that, Your Honor, and make sure counsel and prosecutors are aware of it.
Mr. Conley, you have an absolute right to a trial and you're presumed to be not guilty. And it's your right, if you don't wish to enter a no contest plea, to have a trial. You can still discuss it with your attorney. But right now it's set for trial for December 10th at 8:30. That's the last trial date we have available in the year. We lost both November dates because of a conference and then a vacation. I think he has an appointment with a deer on November 26th. All right, stay in contact with your lawyer. We'll see what's going to happen here. Plea fails. Set jury trial December 10th.
Your Honor, may I ask for just one quick clarification?
Yes.
Do you want witness and exhibits within 21 days of today or 21 days prior to trial?
21 days of today.
Thank you.
Good afternoon, Mr. Jude.
Afternoon.
Good to see you. Your lawyer, Rhonda Ives, is here with me. I'm gonna shut off the live stream here for a minute, and we'll deal with this, and then we'll come back to our afternoon. All right, we've been away for a bit. We did a competency hearing outside of the live stream, which actually went well. And then I did another matter while it was off, and we'll get back to it here. I believe this is our last case of what's been a very busy day. Ever since Miss Stoll and Miss Canfield got here, it got very busy. 39 pretrials is too many to do on one day, so I don't know if you saw the memo. We're gonna go back to doing them in smaller bites.
Just for the record, I can do it.
Well, you did it. Now, I took 8 pleas. I don't know what happened to everything else. I don't know if there were some no-shows.
We had 4 people who failed to appear.
All right, and then so the others were either set with an attorney or a civil infraction or something?
Correct.
Well, we resolved 8 or 9. All right, Mr. Driscoll. Monday, October 6th. That date worked out pretty good, Tim.
Yes, sir.
Mr. Bryant, you've been sitting in the back for a long time, and I apologize. We have been goofing off. We've been busy. And your case is a little complicated. And we were trying to find some case that you were inquiring about, which we couldn't find. So let's talk about what we do know. This is filed. Mr. Driscoll has lots of unpaid fines and costs. $2,000 worth. All right, let's talk about what we do know, Mr. Bryant. Mr. Bryant got a ticket at Pioneer Street and Simpson Road near Mendon on March 23rd of 25 for driving with a suspended license. Second offense, an improper plate. The plate belonged to a F-350 and it was on some sort of Lincoln. Mr. Bryant has been in custody for 27 days. Your lawyer, Mr. Timothy George, is here, as well as Angelique Canfield for the prosecutor's office. Ms. Canfield, what's the plea offer here?
It's my understanding Mr. Bryant wanted to plead guilty to driving while suspended. First offense, we're willing to dismiss the second offense notice.
There's also a charge of improper plates that would be dismissed.
That's correct.
You agree, Mr. George?
That's correct, Your Honor.
All right. Driving suspended first is a misdemeanor. It's punishable by up to 93 days in jail and a fine of up to $500. It does carry 2 points and it would further suspend your license. Do you understand?
Yes, sir.
Other than that, did anyone promise you anything to get you to plead to this
No, sir.
or threaten you?
No, sir.
And you give me the advice of rights, acknowledging that you're waiving those rights by entering this plea?
Yes, sir.
All right. Now, there's more than one Bobby Bryant, which may have been why we were chasing our tails around a little bit.
He is a junior, Your Honor, if that makes a difference.
All right, that may be part of what we're seeing. Because one of these goes back to 80. How old were you in 1989?
I was born in 86, sir.
Yeah, so this was probably your dad. All right.
And that's how this marathon day in court comes to a close. We saw defendants facing suspended licenses, unpaid fines stacking into the thousands, and even a case mixing alcohol, methamphetamine, and a firearm, yes, all in the same proceeding. The common thread? Choices that kept digging the hole deeper, until a judge had to step in and say, enough. From Burlow's Walmart trip excuse to Alcantar's unpaid fines, to Conley's drunken night with a gun, and finally Bryant's suspended license with improper plates, every story highlights how traffic offenses can snowball into serious legal consequences. So, what do you think? Did the judge strike the right balance between mercy and enforcement, or were some of these defendants given too many chances?
Were you driving a car here in St. Joe County
Yes, sir.
on March 25th?
Yes, sir.
And was your license suspended at that time?
Yes, it was.
All right, let me figure out your jail credit because you got locked up and out and locked up. I might even have some money here, I'm not sure. All right.
I think one of them was an error, Your Honor. He was marked as he hadn't appeared, but he actually had appeared and was arrested on that. So I think there was a day or two where he came in on that in the meantime.
We had a hard time getting him in here. We kept calling and he got arrested on July 31st.
That would have been it, because the original pretrial was July 11th. And he was here.
And he got out, so he has 1 day there. And then the 27 days since. You've also got a matter that's bound over to circuit court. Is that one resolved?
Yes, sir.
Have you been sentenced on that one?
Yes, sir.
Let's see if I can tell what your out date is.
I've been trying to, retail fraud came up last week.
Yeah, you asked about that and we can't find it.
They told me, they advised me not to plead guilty, to wait till I talk to the prosecutor. I thought was what happened,
All right.
but I was trying to plead guilty then and there.
To the retail fraud?
Yes, sir.
I can't even find that retail fraud. So were you in front of a judge or magistrate or
Yes,
somebody?
it was here in St. Joseph County. I seen a magistrate and they gave me a $400 bond. And that's it. I've been waiting. I was going to go to trustee status, but that stopped me. So I was hoping to get that resolved quickly.
All right, this might be one of those where his name is spelled wrong or something. I had a couple of these where they didn't show up because they were under.
County jail. They say that I have an open case right now, and it's that retail fraud.
All right, well, let me see if I can find it.
Thank you, sir.
All right, well, in this case, you got 28 days jail credit. Now I'm going to give you 28 days credit, 28 days, and the minimal allowable fine.
I believe I was in front of Patterson. Could be wrong.
Yes, all right, he's the handsome judge in the room next door. 28 days credit, 28 days, $125 minimum fine or 2 additional days concurrent with your felony case.
Thank you, Your Honor.
25276FY. Well, it doesn't sound like you're crazy or you're making this up. You've got some specific information. So maybe we're crazy. They've got a file number on it, 251682, and it ain't in here. So let me look for it by file number. I suspect $50 your name is spelled wrong. That's
I
problematic.
found it, Your Honor.
All right, let me find it.
It's a BOBBIE.
Lupita, that's the third time in a week we've lost somebody because their name is spelled wrong. 2 of them were us. The ticket had it spelled right and we spelled it wrong. What's the file number again?
You had indicated 25-1682SM. And it is a retail fraud second degree.
Well, you're not crazy, Mr. Bryant. Bobby, Bobbie, Bryant. Who did that? Josh Robert and Sergeant Dibble. Now you're in fingerprints, you're in lien, all as Bobbie. They ran a criminal history and it comes back as Bobby. So I'm not sure how that got screwed up, but I don't like when this happens. Yeah, it's spelled Bobby, Bobby. Somehow it got entered as Bobbie. That was on the prosecutor.
I didn't do that.
Well, or the deputy, or somebody, the complaint came in that way. And the other two, we spelled it wrong. But, so it's either from the officer or the person that authorized it. But, well, let's talk about it. The allegation is that on June 5th, you were at the Walmart store and you stole $365 worth of stuff. That's a misdemeanor. It's punishable by up to a year in jail and a fine of up to $2,000. Let's take a look at it. They allege that you were at the Walmart store and you stole 33 items. There's a video of it. You have a distinctive tattoo on the side of your neck that reads love conquers all. And they matched you and your tattoo and they issued a warrant. And then you never knew about it. And at some point, when was that warrant issued? Now, on the sheet here, it's spelled Bobby, Bobby. Anyway, that's why we couldn't find it. Set pretrial conference with the prosecutor. And then that was 9/3, and nothing's happened since. No wonder you're concerned about it. So thanks for bringing it to our attention. What do you wish to do with that charge? Could I have that face sheet on Bobby Frederick Bryant, file 251682SM? It was really screwy.
The people are willing to make an offer of retail fraud in the third degree and request restitution.
All right.
And I have advised Mr. Bryan of that, and he's agreeable to it, Your Honor.
The earlier face sheet was Bobby, Bobby. I don't know how this thing got lost. Prosecutor Camfield. Offer RF third with restitution. All right, do you understand you have the same rights in that case as you have in this one? You'll be giving those up by entering this plea?
Yes, sir.
Mr. George has not officially been appointed to represent you, but he would certainly be willing to if I asked him.
Thank you, sir.
They called you Bobby Boucher?
Yes, sir.
Do you know what that is? Yes, it's from The Water Boy.
That's probably why.
Adam Sandler's character. My kids love that movie. I was in the theater watching it with a bunch of kids. My kids were like maybe middle school age. And they played John Mellencamp's Small Town. It's on the soundtrack. And all those little kids were all rocking in the theater to that. So, all right. Anyway, you're Bobby Frederick Bryant. So were you in the Walmart store and did you take 33 things?
Yes, sir.
What kind of stuff was it?
I believe it was food.
All right. There's different kinds of retail frauds. I had a lady this morning. She stole some things and stole a bunch of personal care items. Sometimes people steal stuff you can sell. And that's drug related. They don't want a power drill. They want the money they can get from selling a power drill. Sometimes people run in and steal liquor. That's quite common. They steal clothing, often underwear, because they can't do laundry. Can you tell from your report, Ms. Camfield, what was taken? Still, if you get me the face sheet on Bobby Boucher here. Thank you. This is Bobby, B-O-B-B-Y. Thank you, Lapita.
I'm looking and that looks like you're supposed to submit a supplemental loss prevention report for the items. And I don't see that here.
I think it was for a friend that had some children and CPS was involved and I didn't have money and I felt bad. So I think I tried to help them out, fill their cupboards up for CPS.
All right, well, let's see what I can.
It does indicate selected multiple clothing items and grocery items.
You're out, what's your out date?
I think if I get on trustee, it'll be somewhere in mid-February, but right now it's April
9th of 26.
Yeah.
All right, so there's no urgency. I understand why you'd want to do this. There's not a lot of trustee slots. They don't have any garage trustees anymore. They don't have any dog trustees. They don't have any outdoor trustees. Sheriff Spence has really tightened things up, and the contraband rate has gone down to about 0. People would throw stuff over the fence, the garden trustees and the mow trustees would bring it in, and the dog guys, and they were having guys wash patrol cars that had shotguns in them. So mostly it's kitchen trustees and inside stuff.
Yes, sir.
All right, and you've got a sentence, and that's the people they like for those positions, and it gets you extra good time.
Yes, sir.
So I'm going to, and you were real upfront about it. You didn't want to get it over with. And you owned it. That is 251682. 27 days, I'm gonna make it, what's the difference? 27 days credit, 27 days. You're not getting out till April anyway. But you could expand it to February, concurrent with 25539 ST and 25660. $125 in fines and costs or 2 additional days. And restitution of $335 to my Walmart. We've had a lot of these lately where the people didn't realize there was a warrant. Somebody commits a retail fraud at Walmart, their internal officers do an investigation, they have a high definition video, they turn it over to the police make an identification, they issue a warrant, so you didn't even know there was a warrant.
No, sir.
And that young woman this morning, she stole some stuff and thought she got away with it. In the meantime, there was a warrant and it took a while for her to get picked up. $335 restitution to Walmart. Due by the end of next year, 12/31/26. It's my last day at work. Actually, 12/30. Don't you pay up before I leave?
Yes, sir.
All right, you got a clear head right now, Mr. Bryant. I don't mean to be unkind, but 27 days in jail has kind of turned you back into Bobby Bryant.
Thank you, sir.
And you're making the choices that are best for you. You'll be eligible for trustee. It gets these cases resolved. You do owe some money when you get out, but you'll probably be on probation to the circuit court. Anyway, that takes care of everything I got here.
Thank you, sir.
Thank you. And thank you to the prosecutor and the
Thank you.
court for honoring that.
Fine. Well, you were adamant that it was there, we just couldn't find it, and then I guessed at what it was, and that is what it was. All right, you're good to go, sir.
Thank you.
Appreciate you.
You can do it.
Your name for the record? You didn't already.
Cassie Coley.
Holy.
Your Honor, you should have a plea form in front of you with a signed advice of rights form.
All right, I have a plea form that indicates that the defendant would be pleading guilty to retail fraud second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. She agrees to pay restitution as ordered. That's the entire understanding of it.
That is our understanding as well, Your Honor.
All right, ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please.
Cassie Lynn Coley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, Your Honor.
And I need that one shut. Do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or gave permission to sign that after going through it with your attorney?
Yes, Your Honor.
Do you have any questions regarding those rights?
No, Your Honor.
You understand that you're giving up your trial rights as contained in paragraph 5, as well as all the rights that are contained on that form?
Yes, Your Honor.
You understand you're giving up your right to appeal of right?
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
December 16, 2020, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Meijer store that makes you think that you're guilty?
I took some items that I did not pay for, Your Honor.
All right. And you tried to walk out of the store without paying for them?
Yes, Your Honor.
Store was open to the public at the time?
Pardon me?
Was the store open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Meijer?
Yes, Your Honor.
All right. Is the second based upon value?
Yes.
All right. Was the aggregate amount or the total amount of the property that you took, was that in excess of $200?
Yes, Your Honor.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, that the court would no longer be bound by any sentence evaluation or recommendation in the case. You understand that?
Yes, Your Honor.
You also would not be permitted to withdraw your plea. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be?
September 24th at 9 a.m.
We can't do the
October
20th.
8th.
Because I need 2 weeks if she's going to be by Zoom. October 8th?
Yes.
October 8th, 2025, 9 a.m. That's before me. Found will continue.
I do have one thing, Your Honor. Miss Coley is
Go
in,
ahead, Parody.
thank you, Lenawee County.
Really? Yeah.
There were warrants issued because I believe failure to appears. They submitted her social worker from Lenawee County PD submitted warrant recalls. Your Honor set these dates but kept the warrants in place. She has approval to go to Bear River, but these are holding her up. So there's this case, and then there's 2 misdemeanors scheduled for the 17th before Your Honor, where there's still warrants. So I'm asking that the court recall the warrant in this case, or all 3 if possible.
She will be in Lenawee the entire.
Well, she's in Lenawee, but she has a release to treatment there. So as soon as these warrants are resolved, she'll be released to Bear River from Lenawee.
In this case, it's before me. I will cancel the warrant. I'll reset her bond at a personal recognizance. $5,000 personal recognizance bond. In the other matters, I suggested you communicate with Ann, and
Okay,
we'll see what we can do on that.
thank you.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the people versus Jennifer Lindsley.
Morning, Your Honor. Raymond Cook, the people.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Lindsay. Ms. Lindsay, please state your name for the record.
Jennifer Lindsay.
Wow, she was right on time. Your Honor, we're asking for an exam date, please.
Discovery is complete.
Yes, my knowledge.
And what facility? She's at Huron Valley, so we could do, I think. If she's at Huron, that'll be enough time for her. Would the people have their witnesses available September 30th?
Yes, Your Honor.
Preliminary examination in person will be set for September 30th, 2025, 9 a.m. That is before
Judge Washington.
Judge Washington. Bond will continue.
Thank you.
Thank you.
We'll be in touch with Ms. Lindsay.
Thank you.
Court does call. Thank you. Court calls the case People versus Terry Probst.
Yes, sir.
An Assistant Public Defender Natalie Pate with and on behalf of Mr. Probst, who appears via Zoom from the Monroe County Jail. Sir, can you please state your name for the court?
Terry Allen Probst.
Your Honor, I have followed the instructions on the Monroe County Jail's instructions to schedule a video visit with my client. I do have an online account created in the system. I do have the facility added. I do have my client added. It is pending approval. So I'm asking for an adjournment. If that is not approved by sometime early next week, I plan on maybe just showing up there in person and seeing what has to happen.
In what?
Asked if I can see them. They might be fine in person. I don't know.
Okay. How long, sir? How long do you do you have a release date? I guess
No, Your Honor. Right now, I'm supposed to record on the 15th, which is Monday.
Got it. Okay. Well, why don't I do this? Why don't I set it for the 9th, like the last one? If he gets out, then he can appear on that day. All right.
That sounds great, Your Honor. Thank you.
Probable cause conference will be set October 9th, 2025, 9 a.m. Bond continue.
Thank you. Thank you, Mr. Probst. I'll talk to you one way or another.
Yes, ma'am.
There was a bench warrant for his failure to appear.
Yes, sir.
That is,
Your Honor, I was in court. I was in here at the time of that bench warrant was issued.
Got it. What I'll do on that is I'll cancel the bench warrant and reinstate his previous bond.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Ardeen Henderson.
And for another for the people?
Brian Bowling on behalf of Ms. Henderson. Ardeen, can you state your name for the record, please?
Ardeen Henderson.
Judge, just for the record, I did meet with Ms. Henderson via Zoom from the Wayne County Jail yesterday. I'm asking for an adjournment so she can continue to work with our AIM division and we can look into further possible resolution of this case. She does have a hearing in Wayne County tomorrow, Your Honor, but she did not know what would happen with that case. So I don't think she's going anywhere for the foreseeable future.
All right. You want the 30th or the 9th?
Let's do the 30th.
Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Court does call the cases of the people versus Ronald Sims.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Sims. Mr. Sims, state your name for the record, please.
Ronald Sims.
So, Your Honor, there are 3 cases before you.
There are.
We are asking for exams in all 3. I will note for the record, because I know what question you're going to ask. 2 of the cases we do not have media discovery on. I've spoken about this with Mr. Sims at length. He would like to set them for exam, knowing that he would not get an adjournment if we do not have it by the exam date.
Is that really what you want to do, sir?
Yes, Your Honor. We'll do that. It was just brought to my attention that it didn't want more rights as well. So that's one something, or we can do that after, later, the next court date. Okay. Yes.
Which 2 do you not have media on?
I don't know the case numbers off the top of my head.
Okay, give me charges.
Largely from a vehicle, we have media. On the other 2, we do not.
So the B&E vehicle you do not have or do?
Okay, in the case ending in 5717, we do.
5717 you have.
Yes. The other 2, we do not.
All right. Fair enough. People have their witnesses available the 25th. So 12 days out. No, let's see. Well, what's my date? 23rd. Got it. I guess I should say September 23rd, which you have people. Council. 23rd. Will that preliminary examination in person will be set for September 23rd, 2025, 9 a.m. before Judge Barr on all 3 matters. Bond will continue.
It's time.
Court does call the case People versus Anthony Williams. In case. How many AG cases, Joe?
Just 2. Good morning, Your Honor. Assistant AG Clarissa Williams.
Assistant Public Defender Chelsea Vergil is with and on behalf of Anthony Williams. Please state your name.
Anthony Williams.
Your Honor, I'm asking for, if possible, 1-week adjournment. I did receive an offer from the Attorney General yesterday after I was speaking with Mr. Williams. So just to keep things moving along, asking for a very short adjournment.
1 week would be the 18th. Madam Judge, in probable cause conference, September 18th, 2025, 9 a.m. Bond continue. Thank you.
Thank you.
Court calls case People versus Brandon Kelly.
Assistant Public Defender Chelsea Vergil is with and on behalf of Brandon Kelly. Mr. Kelly, can you unmute and state your name?
Yeah. Yeah, let me see slide of it. I got it. All right, Brandon Kelly.
Your Honor, we're asking to adjourn this for media, and may I address bond?
Probable cause conference will be adjourned to September 25th. Yes, that's about.
We are asking the court to consider a personal bond or a very low cash bond. Mr. Kelly has a plan for, if he's released, he would stay with his parents. He also would be in treatment with CMH. He does not have a criminal history, understands his bond conditions, and I think it would be beneficial to him to get that mental health treatment out of custody. He has been in custody for 70 days now. So
Only on this case?
he had another misdemeanor. My understanding was that the bond was set at $100 on that just to get time served.
He does have another case. I'm sorry, I don't know if the counsel is finished. It's completed their.
I'm finished. Thank you.
So Your Honor, we do believe that Mr. Kelly still is in a danger. With Mr. Kelly, while it is true that he has a CMH plan, it's a result of being petitioned while he was in jail. That petition last month, because he was threatened to kill a jail staff member, to injure jail staff. He refused to take any medication. Your Honor, it was indicated that I checked the register of actions. He just had his hearing 2 weeks ago, and at that hearing, he was found to be a person in need of treatment. That he, one, is a danger to others, and also doesn't necessarily recognize the amount of treatment that he needs. And
That treatment is completed.
Okay, thank you for interrupting. Go ahead, Mr. Douglas.
So Your Honor, I know in the petition that it did indicate that the petitioner was recommending that the jail be able to give Mr. Kelly shots of antipsychotic medication since he would not take medication. So while I'm sure in the last 2 weeks, he might be benefiting from that medicine, I feel about whether he will continue that medication once he's released. The allegations here, I think, indicate a danger to the public. If there had been some ongoing treatment that he seemed cooperative with, I would feel different. But in this case, he's accused of punching a Target employee in the face where he busted his lip by using a watch wrapped around his knuckles as a makeshift metal knuckles. I would also note that in the other case, he was accused of following a stranger to a library bathroom. When that individual turned around to find out why Mr. Kelly had followed into the stall, Mr. Kelly asked him what he's looking at, and then he punched that individual in the face, giving him a black eye. So with such a short amount of treatment, given that he's had a history of non-compliance, I don't think at this time that it's safe for the public.
Anything else?
I would just say we're not denying that he has had, mental health struggles and he is going to get help with that. I think that the circuit court order for assisted outpatient treatment is a determination that it is appropriate for him to be getting outpatient treatment rather than being hospitalized or some more restrictive alternative. I also think with a supportive family, he would do well in that environment. So we still ask the court to consider that.
Motion for bond reductions denied. Bond will continue. Thank you.
When's the next court date?
25th.
Thank you, Your Honor.
Court calls case People versus Imbaye. Yeah.
Good morning, Your Honor. Assistant Public Defender Ravi Leba on behalf of Mr. Ngai, which I believe is the correct pronunciation. Yeah, Bye, Baba. Mr. Ngai, could you please state your name, sir?
My name is Baba.
And good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And Your Honor,
what are we doing?
And Your Honor, I do have a green sheet. We would be requesting an adjournment. I would ask if the court could provide 60 days. I realized that was a long shot, Your Honor.
Oh, I was going to listen to your reason for it and then tell you no.
I would like the court to hear, I realize it's long, but I do want the court to hear my reasoning, which is Mr. Ngai has a significant amount of arrearages. We do have an offer that will be contingent on him paying off those arrearages very significantly to around the $13,000 amount, and he believes he can do that if he's given that 60-day adjournment.
Is it a misdemeanor resolution?
The offer would be for a delayed sentence at circuit court.
So wouldn't it be wise to waive it to circuit court, see if he does it, and then they can? That would seem to me to be the way to handle it.
I don't disagree.
It doesn't matter to me.
I don't disagree.
I'll keep this one too, but
I don't disagree, Your Honor. I did email Ms. Williams to ask if she would agree to hold that offer open at circuit court, but in the absence of a reply, I felt it was best to request the adjournment.
Okay. Madam Attorney General.
Oh, well, I mean, it's like Judge Simpson said, those offers were contingent upon you waiving the preliminary exam. So either way, I think at some point you would have to do that. I mean, of course you can wait. And if you have it at that point, then we can waive it and go and finish the process. But again, they were contingent upon you waiving the preliminary exam.
So if I understand, that offer would be held open if Mr. Guy were to waive today.
If it's
Yes.
contingent upon, it seems to me it would have to.
We do this all the time. Yes, it would be.
Yes, you do.
Thank you, Madam Attorney General. Would you be okay with completing this issue at third court? So you would skip the exam. Your Honor, could we
Your other case, we adjourned out 1 week, correct, Madam Attorney General?
That is correct.
All right, let's just do this so that they can have a full conversation.
Thank you, Your Honor.
Probable cause conference will be adjourned to September 18th, 2025, 9 a.m. Bond continued. Okay. Thank you. I think that's your last case, isn't it?
It is.
Okay. All right, have a good day.
You too.
First up, we've got Cassie Coley, facing a charge of retail fraud, 2nd degree. Translation? Shoplifting, but serious enough to carry up to a year in jail and fines that could triple the value of whatever she swiped. And here's the twist: by pleading guilty, she avoids a trial, but she's also giving up her right to appeal and locking herself into whatever sentence the judge hands down. And it doesn't stop there, her attorney's already flagging other warrants in different counties that could derail her rehab release. So buckle up, because what looks like a simple shoplifting plea might unravel into a chain reaction of bigger problems. Let me ask you, if you were the judge, would you cut her a break for treatment, or hold her accountable for skipping court in the past? Comment below while we watch this play out.
Court calls the case People versus Anton Brooks.
And for others for the people.
Good morning, Your Honor. Brandon Bird on behalf of Anton Brooks. Anton Brooks. And Assistant Public Defender Ben Dunaway on behalf of Mr. Brooks on the case ending in 1261. Your Honor, we're demanding on the 1261 case. Pardon? We're demanding exam on the 1261 case. And we're respectfully requesting exam.
No, I appreciate no. So he'll get his. You keep up with your demands. No. Discovery on both of these matters is complete.
Yes, Your Honor. As far as I know, Your Honor, I was told that there is no body cam in this. I just wanted to make sure that's correct.
There's no video in the case of Mr. Bird. That is RNO that it wasn't on the street. It was actually here at the service center in between exams. Yes, Your Honor. So there was nobody.
Okay.
Oh, and I have it that they pulled him over for tent. For his tent on
the hallway?
For the RNO?
Correct.
Well, Mr. Bird's on the, hold on a second.
Sorry.
Denowith is on the RNO. And
Sorry, I thought you were on RNO.
So, do you know when you can provide me that body cam, please? Say what? This is 2 weeks ago. You say what? We went through this 2 weeks ago.
Don't have any.
so they're indicating there is no media.
Respectfully, we'd like to respectfully request exam, yeah.
Okay, people have their witnesses available the 23rd.
Yes, Your Honor.
Preliminary examination in person in these matters, September 23rd, 2025, 9 a.m. before Judge Freshour in both matters. Bond will continue.
Thank you, Your Honor.
Court does call the case of the people versus Demetrius Job.
Good morning, Your Honor. Please, Honorable Court, David Burgess on behalf of Demetrius Joe.
All right, what is your name, sir?
Demetrius Joe.
Thank you. What are we doing?
We're setting a preliminary exam on this matter.
Discovery is complete.
Yes, Your Honor.
People have their witnesses available the 23rd. Preliminary examination, September 23rd, 2025, 9 a.m. That is before Judge
Barr.
Judge Barr.
Thank you, Your Honor.
Thank you. Bond, continue.
Me too.
Court does call the case of the people versus Quentin Coleman Ebersol.
And then on behalf of the people.
Your Honor, Joe Simon on behalf of Mr. Coleman Ebersol. State your name, Quentin. Quentin Coleman Ebersol. Your Honor, in this case, the people and I are engaged in some negotiations. There's also a little bit of continuing discovery. Ms. Zenda is going to be leaving town next week, but she and I have pledged.
What?
Yeah, that's what I hear.
Oh.
Do I have a new last name I need to learn? Because I keep tripping over Londi.
Never know till they get back. We will.
Yeah.
We won't. Sweet. It's been hard, Ashley. I'm sorry.
In any event, we have pledged to try to make a resolution actually before she goes. And we're asking the court because part of that resolution may involve possibly a stipulation as to bond. So asking the court if it would adjourn the matter 1 week, and we will not address bond today in consideration of those discussions.
But hold it. Zenda won't be here next Thursday.
Right, but we're hoping that we will have our matters resolved by when she leaves so that somebody else can just stand in her stead.
She's leaving Tuesday.
She told me.
I'm sad.
Me too.
I'm happy for her. But I'm sad.
I'll be back.
Okay, that makes me feel better. All right. Don't like to do that, but I will. Understanding that September 18th, 2025, 9 a.m. Bond continues.
Thank you, Your Honor.
Thank you. Court does call the case, People versus Juliet Burns.
Morning, Your Honor. Raymond Cook, the people. Good morning. I'm Rob J. Cool on behalf of Ms. Barnes.
Judge, I'd like to give you a sad story. This is you being the considerate judge you are, this could be a tearjerker, but not being facetious. I met with I was appointed yesterday at 4:00. I met with her last night at the jail. They told me she was in a long line of list people to be released. They didn't know when she was going to be released. I told her if she was released, she had to be here at 9 a.m.
Is this where we get to the sad part? Because she's not here.
She's not here, but
she got released. She's not here. I'll let you go.
And she doesn't have a phone. So I called her friend at the apartment who is racing down to the 5th floor of the apartment complex. Judge, long story short, can I get a 1 week adjournment on this matter?
Did you cry? No. She's not here.
Judge, I understand that, but she may have been released at 1:00 last night. All I'm saying is, can we get a 1 week adjournment, please?
Here's what I will do. Bench warrant will issue for defendant's failure to appear. Bond will be set in the amount of 10,000. Cash surety. That warrant I will not issue until
late September.
September 16th.
Thank you, Judge. I appreciate your.
What?
So we could technically walk in next week then.
Okay, technically do anything you want. I don't know where you're walking into. The jail?
I'll just let that go. Thank you.
All right. Calls the case. People versus Sean Odom.
Alexander on behalf of the people.
Yes, Your Honor. Brandon Bird on behalf of Sean Odom. Mr. Odom, can you please state your full name for the record?
Sean Martell Odom.
Please, Your Honor.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Yes, as to bond.
Your Honor, it's come to my attention that Mr. Odom has tried to call the victims listed on the report from his own pin 7 times since he was arraigned. He wasn't able to connect, but at this time I'd be asking that his phone would just be revoked, given that he's using his own pin to call the listed number after being arraigned and will not have contact.
Mr. Bird.
Respectfully, Your Honor, I haven't been presented with any evidence of that matter, and we just respectfully request that he keep his phone calls until it's presented to me in the court.
Well, certainly you'll be entitled to a hearing, but in the interim, defendant's phone privileges are hereby revoked. With that change, bond will continue. Thank you.
And what?
25th.
25th? Thank you.
Yes, sir. Court does call the case, People versus Cedric Green, no relation.
Your Honor, people.
Wow.
Good morning, Judge.
Good morning.
Beautiful day today.
Well, you're gonna change that.
No. Well, Judge, just for the record, Christina Costantino appearing on behalf of Mr. Green. Unfortunately, it doesn't appear that Mr. Green has arrived yet to court. I was
You expecting him?
Yeah, sure. I was just assigned his case yesterday. So perhaps he has not received my letter yet, asking him to contact me and that sort of thing.
You sent a letter?
I did send a letter, always do.
Did you email?
Just in case. I did email. Yes.
Oh, okay.
Yes, I also called, but I have not been able to get in touch with him, unfortunately. So given that,
Mentioned that letter.
the letter, the mail,
Yeah.
not that quick. But I would ask respectfully for an adjournment of this matter so I can have a little bit more of an opportunity to allow the mail to get to him and, contact him.
Really? Constantino, you called them and you sent an email.
I don't know if that
We're waiting
contact
on snail mail?
I don't know if the contact info is valid. You never know. People's numbers change pretty rapidly these days.
Bench warrant will issue for defendant failure to appear. Bond will be set in the amount of $10,000 cash surety. That warrant will issue immediately.
Thanks, Judge.
Thank you.
Can't say I didn't try.
No, you did. That was an epic fail. All right. Court calls the case. People versus Sherry Walker.
Yes, Your Honor. Brandon Bird on behalf of Sherry Walker. Ms. Walker, can you please state your full name for the record?
Sherry Walker. How you doing?
All right, we got a little bit going on here today, Your Honor. My client she wants to plea. She completed Don Farms. I did speak with Sister Prosecutor who said if we provide a certificate of Don Farms, that she would allow her to plead to a retail fraud second. Ms. Walker wasn't able to go back and get her certificate.
Go back where?
Go back to her cell to get her certificate. She did ask the officer, and I also
they were a little busy.
Right, Don Farms was a little busy. There's a lot of busy, but I did try to see if I could find Don Farms within the building, and unfortunately, I wasn't able to get a hold of him. So I know Ms. Walker doesn't want to adjourn this anymore. And she wants to take responsibility for her actions and take Sister Prosecutor up on her plea. I'm wondering, first of all, if you have a copy, and if you want
of what?
Of her Don Farm certificate.
That'd be a no.
Okay, if not, then
can I get it for her?
What?
Later on, can I have her to send it to you later on?
I gotta give it to the prosecutor.
Okay.
Then unfortunately, I did everything I could, but we're gonna have to adjourn this matter, but I would like to address bond on Ms. Walker.
Here's what I'll do. I'll let you address bond if you want. Rather than adjourn what would be a customary 2 weeks, I would adjourn it out 1 week if she gets a certificate, because the other paperwork has to be completed for me to take the plea in any event.
Thank you.
Does that work for you, Ms. Walker? I realize you don't want it adjourned, but.
Okay, can you say that again? Repeat that?
I'll adjourn it out 1 week, which would be a shorter time period than I normally would.
Okay.
Because you've got the certificate, it just needs to get there. They also then have to fill out paperwork for me to take the plea. So I'll do that for you.
Okay, I appreciate it.
Okay?
Absolutely.
I'll do that for you. I'm not doing it for him.
Okay, good.
Okay?
Whoever you do it for, Your Honor, I appreciate it.
Probable cause conference will be adjourned September 18, 2025, 9 a.m. Bond continue.
Right.
Thank you. Court does call the case of the people versus Clyde Harris.
Morning, Your Honor. Raymond Cook for the people.
Harris?
Twice.
No, Judge, this one's here.
Oh, I told you, he knew his name.
Here and looking very professional, Judge. Christina Costantino, appearing on behalf of Mr. Harris, who is present here. Mr. Harris, could you please state your name?
Malachi Harris.
So I told you.
Judge, this is a date and time set for PCC. I was just assigned on Mr. Harris's case this week, so we would be respectfully asking for an adjournment of the probable cause conference to ensure discovery is complete.
Probable cause conference will be adjourned September 25th, 2025, 9 a.m. Bond continue.
Thank you very much, Judge.
Thank you. Malachi, thank you. I think, where's this person? Yoder? They got him? Her? Court calls the cases of the people versus Jessica Yoder.
Christina Costantino appearing on behalf of Ms. Yoder in case number ending in 1282 FY.
And Stephanie Cannon appearing on cases ending in 1283 and 1060.
Wow. Yeah,
I'm here.
it was a lot quieter last week.
I haven't said anything.
What?
Yes, it was, Your Honor.
Yeah, you
Yes.
weren't here.
I wasn't here.
Everybody
I missed
commented
you
on how
though.
quiet it was.
I missed this whole thing.
We missed you too.
It was so sad.
Oh, constant. Nobody here missed it. All right, anyway, go ahead. What are we doing?
Well, first, Ms. Yoder, can you state your name for the record?
Jessica Yoder.
Thank you, Michelle.
Judge, we need a little bit of additional time for further negotiations. We are trying to work out a global resolution for Ms. Yoder in all of her matters. So we would be asking for an adjournment of the PCC.
Are you saying in all of these matters, or are there other matters elsewhere?
Well, Judge, she has these matters. She has a violation of probation up before Judge Washington in 14B, as well as one other matter in front of you. That's a misdemeanor matter.
Right. And so the one before Judge Washington, when is that set for?
Judge, it was supposed to be heard this week, but it got moved to the 18th. Is that correct, Jessica? The 18th of this month, September.
So what I'll do is I'll adjourn probable cause conference to the 25th, 2025 at 9. Bond will continue.
Thank you very much, Judge.
Thank you. Court does call the case of the people versus Philip Barnhart.
Patrick Elvis for the people in both matters.
Assistant Public Defender Ben Dunaway on behalf of Mr. Barnhart, who stands to my right. Would you state your name for the record, please?
Philip Barnhart.
What are we doing?
Your Honor, Mr. Barnhart is prepared to waive his exams. I think there may be another issue that the APA wants to bring up, though.
The court received the bond violation report from Community Corrections.
I have a report dated September 10th, the progress report, yes.
Yes, Your Honor, and I understand that the defendant was released from jail on September the 2nd, went to community corrections to test on September the 3rd. And when he tested on September the 3rd, he tested positive for cocaine, THC, benzodiazepines, and Suboxone. I understand also that this was his first test, so there is an argument that he may not have been on bond at the time that these substances were consumed, therefore it may not be a bond violation. However, I did double check ex-jail and he was booked on August 31st and released on September the 2nd. So there were 3 days in custody. It's possible that certainly the THC could have been from before. The cocaine, I'm less certain of, with extremely heavy use, maybe 96 hours on cocaine, but no matter what, these are OWIs at least 4 and 5, and there's another pending OWI in Wayne County. I'm very concerned that he is not able to control his substance use and is a danger to the community.
Your Honor, I believe there's a window that would make this not a bond violation. I think if he would have used on August 30th or the 31st.
But if this is a 5 and this is showing up in his system at all, I would consider him a danger to the public and that his bond is inappropriately set. So I'll let you make your argument, but.
Can I have just a second, Your Honor?
Sure.
So, yeah, I just think there's possibilities that he's not used after being arrested. And those.
What?
I mean, cocaine could stay in his system for up to a week if there's heavy use. So the failure.
Let's say, I don't know, a week, but let's say I agree with you regarding that. Then his bond, and this is what I'm saying to you, then his bond on these operating while intoxicated, I have 2 in front of me and there's another one in Wayne County, then I think that his bond in these cases is inappropriately set. And what I mean by that is that I clearly have these 2 cases. There's the other one in Wayne County. He's got priors and he's still using.
I think I'm fine. I think that's all factually true, Your Honor. Or he's at least not passing the test. Would the court be willing to have him test today?
Would he come back clean?
Yes, sir.
But here's again my problem, counsel. My problem is really the danger to the community. Because I have an incident that occurred in February of 23. This other one occurred in July of 2023 or 23. He's got a pending Wayne County one. He's got prior ones and he's still using. So I don't know that he should be out because at some point luck's going to run out. He's going to get behind the wheel and he's going to take somebody out. I don't have a vehicle.
Your Honor, I don't believe he's driving. The test certainly indicates use. Look, drunk driving is absolutely dangerous, but there's no dispute. I think if he's using drugs in his own home, I don't believe that's a danger to the community that rises to the level of him needing to be incarcerated. I think he can remain out if he fails a test. That would be a bond violation at this point because he has been on bond since, I think that would be the 29th, 28th or 29th. So if he fails the test at this point, that would conclusively prove use while on bond. And I think absolutely the court at that point would have undeniable jurisdiction to revoke his bond. I would say that I don't believe the information in front of the court at this point proves he's actually a danger to the community.
So you're arguing to me that with all, this is legitimately 4 and 5 with another one pending in Wayne County and he's still using, you're saying.
And there you have it, another whirlwind docket in Judge Boyd's courtroom. From Brandon Kelly's denied bond reduction despite his mental health treatment plan, to Anton Brooks and Demetrius Joe setting their exams, and even Philip Barnhard facing serious concerns over repeated substance use. The tension between accountability and second chances was on full display. Judges made it clear, community safety comes first, but defense attorneys pushed hard for rehabilitation and treatment. What do you think? Should someone like Brandon Kelly be given a chance at treatment outside of custody, or did the court make the right call keeping him behind bars? Let us know in the comments. And if you found this case breakdown as intense as we did, don't forget to like, share, and subscribe for more jaw-dropping courtroom drama.
It doesn't show to me that he's a danger to the community.
I think if he was driving, I wouldn't absolutely not even argue that, no question. I think him failing those tests, and we don't have a pattern or anything like that. You know, we don't know if this is a one-time slip up. We don't know if he's used while he was on bond. I think the court could allow him to test today, and that would solve the problem.
May I respond?
Right.
I would wholeheartedly disagree that there's no pattern. I think that the defendant having 3 previous convictions for OWI in 2002, 2004, and 2016, a 2023 Wayne County case, a 2023 Washtenaw County case, and a 2024 Washtenaw County case is absolutely a pattern. Furthermore, Your Honor, in this matter, if I recall correctly, and I think I do, but I will make sure, I believe his BAC was incredibly high. And I'm going to double check that before I give that search to the court. But if I recall correctly, I think in both cases, his blood alcohol content was above a 0.3.
That's correct, Your Honor.
So we are not, if this isn't a pattern, I don't know what a pattern is. People would request that the court find that the bond is an abuse of discretion and set a higher bond and remand.
I just don't think the circumstances have changed since the bond was set, because and I know the court could disagree, but we don't believe there's evidence he's used since the bond was set by the magistrate, at least conclusive evidence. It's up in the air as far as he failed the test.
You keep arguing the use. The argument is, even if I give you that, the argument is I don't know that he should be out. Any use, given his record, and he's out on basically a PR, I think is an abuse of discretion. Now, if you want to argue that with me, certainly I will hear you.
Okay. I think it would not be abuse of discretion because of the length of time that has passed. So, we're already into August 2025. The positive test, we can't really deny it, but what we can say is he's not driving a car. So the extreme danger to the community that comes with intoxicated driving is not present. Obviously, there's some danger to the community in hard drug use, but I believe it's less. I believe it can be managed with restrictions such as continued testing. If he fails again, he's obviously used while on bond. The court could do that. I think the court could order increased testing. You could put him on 3 times a week. I think he was on 1 time a week. I mean, the court could order testing every day if the court felt that necessary. There's a lot of options other than just incarcerating him.
What did you wish these set for?
I'm sorry?
What did you wish these set for? Preliminary examination?
No, he's going to waive.
He's waiving? All right. So at this point, what I will do is his bond is going to be changed. I'm going to set it at $25,000 cash or surety. Sir, you're waiving your right to preliminary examination in these cases?
Yes, sir.
You understand that a preliminary examination is a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, sir.
You understand you will not have that hearing on either one of these matters, and that this will proceed to circuit court for further resolution?
Sir.
People also waive their right.
We waive, Your Honor. I do believe he previously posted $25,000.
Oh, are on both of these?
I think that's what my notes reflect, is that that's what it was set at.
I mean, I thought they were PRs.
It might be PRs, maybe $25,000 PRs, but
I have on each of these that they're PR.
Oh, I apologize, Your Honor, my mistake. Thank you.
So people do waive
We do.
preliminary examination, haven't been waived, defendants bound over to circuit court on the single count in each case.
We will stand mute, waive the formal reading.
Defendant having waived formal reading, standing mute, court will enter not guilty plea pretrial. Can we go to custody pretrial date?
September 24th at 1:30 with Judge Sean.
September 24th, 2025, 1:30 before Judge Conlon in each of these matters. The bond as indicated is set in each case. It will be changed from a personal recognizance to a $25,000 cash as surety. Defendant is remanded. Yes, you may. Court does call the case of the people versus David Davis.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Davis. Could you approach you now? Mr. Davis, will you state your name for the record?
David Davis. Thank you.
Your Honor, we are asking for an adjournment, and then I did wish to address bond on behalf of Mr. Davis.
Basis for the adjournment.
The adjournment, partially as part of the bond argument, but that he can begin treatment at Dawn Farms, which he has set up to begin next week. I'm sorry, tomorrow.
Inpatient.
It is an outpatient program. You revoked his bond last week for the positive test. He is willing to acknowledge that positive test. He did contact Dawn Farms before coming to court last week, completed the initial intake, and is scheduled for his assessment to begin outpatient treatment tomorrow at noon. Based on that and his admission to the cocaine and THC use, I'm asking the court to consider reinstating his personal bond so he can attend that appointment. I did provide verification to opposing counsel last week, a letter from the treatment provider and information regarding, of course, I think based on that assessment, tomorrow is going to determine what level of care he's going to be needing. But I advised him that, I'd ask the court to order that he comply with whatever they recommend, if it's regular outpatient, intensive outpatient, or even inpatient treatment. And he's willing to do just that.
I would need is there any response from the people on that?
Your Honor, this is Mr. David Davis, correct?
Yes.
Trevor Mayville for the people. When the case was called, my office had some confusion as to what his first name was and who the case that was being called. So I wanted to enter my appearance for the record. Normally, it seems we don't get in the way of release to treatment orders, but this doesn't appear to be what defense counsel is requesting. This is a felony file along with a high BAC charge where, in addition to the defendant's blood alcohol level being north of 0.18, he also had active metabolites for THC and cocaine in his system. He's given a relatively low cash surety bond and asked to submit to testing. And in the 3 weeks that followed his release, he was positive for both THC and cocaine in all 3 tests. And that's what was the basis for his bond revocation. I would not oppose a release to treatment, but I'm concerned about his narcotics usage if not done so.
Judge, I don't believe that statement is correct regarding the cocaine use. He had 2 positive tests for cocaine, which were shortly after his arraignment. He tested the next day, and then he did test, I think roughly about a week later, and there was a positive test for cocaine and THC. And he acknowledges
that powerful cocaine that's lasting a long time, like the last kid. Go ahead. I'm sorry. That was just me.
Yeah, I'm not going to make that argument for this case, but however, he did have a negative test for cocaine. There was still THC in his system. He reports that he has stopped use. He reports that since being incarcerated, he's also made contacts to try to work out a medical marijuana card upon his release. He will not use until that card is received and provided to community corrections. If the court allows.
I get it, but he shouldn't be using it all. He's got serious issues. And the very fact that he wants.
I mean, I think that's between him and his provider regarding the medical marijuana, but I think it's noteworthy that he had a negative for cocaine. He's been incarcerated for a week. He set up treatment. He has it scheduled to begin tomorrow. I would just ask, based on all of that, he is also on a scram tether. I understand the basis of part of the OWI is obviously BAC. There was no issue regarding alcohol consumption on bond. He still has a scram tether on. I don't think that that's been of any issue, and he's doing everything he can to show the court that he's compliant and willing to work that out. And he's been in custody the last week. He I would say fairly from our conversations, has very much learned his lesson and understands if there's even the slightest slip up, that he's going to be back in here and he's not going to have a chance to get out. But I would just ask for the opportunity so that he can keep his treatment appointment tomorrow that he's scheduled. And
All right, here's what I'm gonna do. I'm gonna need an order. I'll allow him to go to Don Farm, but prior to him going, I realize he's got a scram tether. He's gonna have a GPS tether on his other leg, because if he leaves that program, doesn't cooperate in that program, he's going right back in.
Understood.
So I'll need an order.
Okay, I will prepare that today.
Thank you, Your Honor.
All right, thank you. What is it?
It's gonna put you.
You can. Hold on.
And
And I returned this out to the 25th of Bible, continues with that modification.
just until I get the order to the court and they can put it out. Hopefully today.
Court calls the case of the people versus Douglas Brown. All I have. So I don't like the way these are put up. So what?
Douglas Brown.
Douglas Brown.
Oh, I'm sorry. He's on Zoom. My apologies. Assistant Public Defender Hannah Apple appearing on behalf of Mr. Brown. Mr. Brown, will you state your name for the record?
Douglas Brown, sorry.
Thank you.
Your Honor, we are asking the court to consider a very brief adjournment of 1 week. Mr. Brown is retaining counsel. There's been communication regarding Mr. Vincent's office, and I spoke with Amanda
Are they going to
today.
enter their appearance?
They plan to file that all today. The appearance and the substitution.
Did you talk to Mr. Vincent?
No, I talked to Amanda.
Okay, then I'll believe it.
Okay.
Thank you.
You just need a week?
That's
My condolences to your family, first of all. And secondly, though, you guys sent him here alone last week. So I don't know what?
As you can understand why I had to.
No, I understand why, but yeah, I don't know I can't remember what he did.
I'm sure he messed it up.
Oh, he did, but I just don't know what day.
We do have a matter in front of you next week on the 18th. So it most likely was that.
That was, so just so you know what he said. Just so you know what he said. He walks in and I said, "You're here alone." He said, "Yeah." I said, "Okay, so what dates did they give you?" He said, "They just said any date." I don't think that's what you said. That's okay. But if,
And that's how I know that you know me, Your Honor.
yes, I know. You would have given him a date and he would have, well, anyway. All right, I will on this one, if he's gonna retain, then I'll adjourn it out 1 week.
Thank you, Judge.
Go with the other 135. September 18, 2025, 9 a.m. bond continued. All right. Thank you, Mr. Douglas.